All right, welcome everyone. Let's get started. I'm Natalie Hanlon-Lay. I'm the Chief Deputy Attorney General here in the Colorado Attorney General's office. And we are really delighted to have you join us today for our Data Privacy Day panel. Data Privacy Day is a national event that is designed to raise awareness and promote privacy and data protection, best practices for businesses, policymakers, et cetera. We had our first Data Privacy Day event in meeting last year on this same date, and we're really delighted to be able to continue it today. This event has been put together by the DOLs, that we call it the DOL, the Department of Law's Cybersecurity and Data Privacy Impact Team. When AG Weiser came on board, he charged me with putting together a group across the department of folks that work on data issues, data privacy, cybersecurity. And we have had a really robust group that works on policy issues, how to advise our state agency clients, how to advise consumers on best practices, and then thinking about the larger kind of context of data with regard to issues that state AGs can be assisting on. It's been a really interesting journey, and one of the fun things we get to do is this event. I'll note that we are planning some future events that will we're going to make Data Privacy Day perhaps Data Privacy Month and a Half that address more specifically issues involving data breaches and some of the hot topics that are going on, particularly with cybersecurity. But today we're really excited to talk about data and some of the issues involving big tech from a different lens, and that's the antitrust lens and competition law, which is clearly something that has been a priority for state AGs, and there is a lot of activity, and I think our panelists today are going to have a lot to say about that. Talking about competition law and how enforcement protects consumers and how and why states are working together in the Facebook and Google cases. So I want to give a big thank you to our panelists today, Danny Katz from Coburg, Diana Moss from the American Antitrust Institute, and then Attorney Generals Weiser and Peterson. And with that, I am delighted to hand it over to Diane Hazel, who is the first Assistant Attorney General in our office responsible for leading our antitrust work. So with that, I'll kick it off to you, Diane. Thanks.
Thanks, Natalie. Good morning, everyone. We have a great first panel, so I want to do some introductions. We have Diana Moss. Diana is president of the American Antitrust Institute. Before joining the American Antitrust Institute in 2001, she was at the Federal Energy Regulatory Commission, where she coordinated the agency's competition analysis for electricity mergers. Dr. Moss has spoken widely on various topics involving competition policy and enforcement and published articles in a number of economic and legal academic journals. She has industry expertise in digital technology, electricity, petroleum, food and agricultural, airlines, telecommunications, and healthcare. Dr. Moss holds an MA degree from the University of Denver and a PhD from the Colorado School of Mines. She's also adjunct faculty in the Department of Economics at the University of Colorado Boulder. We also are joined by Danny Katz. He became the director of the Colorado Public Interest Research Group in 2009. His advocacy work spans multiple issue areas, including consumer protection, transportation, recycling, campaign finance reform. In 2016, he wrote a groundbreaking report on the transit, walking, and biking needs in Colorado. Then in 2018, he was a leader in the effort to pass Proposition 111, a 36% cap on payday loans in Colorado, which passed with over 70% of the vote. He's the chair of the Denver Streets Partnership, co-funded the Financial Equity Coalition, and serves on a number of Colorado Department of Transportation committees. Between 2001 and 2009, Danny was a grassroots organizer and organizing director for nonprofits in Wisconsin and California. Born and raised in Boulder, he received a BA in history from the University of Virginia in 2001. Welcome both to Diana and Danny. Thank you.
Thanks for having me.
So,
thank you.
Thanks. To start us off, the focus of today's discussion is on big tech, competition, and privacy. And just taking a step back to start off, why is competition a good thing?
Well, I'm happy to chime in, and it's just an absolute pleasure and an honor to be part of this discussion. AAI, as the leading nonprofit competition advocacy research and education group, very supportive of public and private enforcements in not only in the area of big tech, but certainly for all markets that are so important to consumers. I always think of antitrust, it's a small part of the law, but it has an outsized impact on our citizen consumers, our free market system, and certainly the democratic principles that undergird that. I always think of it as having really two purposes. One is just to prevent consumers and workers from getting ripped off by paying higher prices, getting lower quality, less choice, less innovation. and then, the other prong of the purpose of the antitrust laws is really to prevent the concentration of economic power in the hands of the few. And we know that economic power can translate into political power. And so that, the first prong really goes to equity and distribution of wealth. The second really supports our democratic system.
Yeah, and I agree with everything that Diana said, and we have been proud to work with them over the years, both CoPIRG and our national network, US PIRG. It really comes down to me, it's some of the words she said, it's choice. It's the ability to have innovation in our marketplace. And if you don't have those things, then it oftentimes results in consumers being ripped off and higher prices.
So let's talk about big tech. There have been several large antitrust cases filed recently against big tech, Google and Facebook. Danny, you may be able to answer this question, but why does enforcement against big tech specifically matter for consumers?
I think it really matters because we've seen some really sloppy enforcement over the years. I think there's been a belief that somehow enforcement is only about price, but when you get into the kind of things that you see in the big tech space and really tech overall, there is an argument that, this is all free, so there's no problems. There's no reason to have these sort of antitrust cases brought forward. But it goes back to a couple of the things I said, which is choice and the ability to see innovation in the marketplace. And so I think we've had some sloppy enforcement in the sense that a lot of focus on price, but when you have something like the internet, a lot of times it can be sold to us as if it is free, but we still have harm when it comes to lack of choice or lack of innovation. And even the argument that somehow the products, the services that we're getting are free is not true. This goes back to the privacy issue and the data issue, and why we're here today and connecting these two dots is because, when I'm on these platforms, I'm being watched, my data is being collected, and that data is very, very valuable to me. And so these services are not necessarily free. They are taking something that's very valuable to me and using it and sharing it in a whole host of different ways. And so it's really important that we stop being so sloppy with our antitrust work and actually enforce the rules that we have and create some stronger rules to ensure that the tech marketplace is just like any other, where there's choice, where there's innovation, and where consumers have control over the things that they value, including the data and personal information.
Yeah, just to dovetail on what Danny, so aptly described is that, there's this myth that the antitrust laws can only reach to things like adverse effects on prices. On the consumer side, that's higher prices. On the worker side, that's lower prices paid for their labor and their commodities. That's not true. Antitrust law has a pretty flexible standard that it uses to evaluate harms to competition and consumers. It's called the Consumer Welfare Standard. And that standard looks at both price effects and non-price effects. And the non-price effects really do incorporate anything ranging from quality to choice to innovation. The problem is that most antitrust cases historically have really focused on not only just on price effects, but very short-term price effects on consumers. And so there's been some skewing or unbalancing of how the courts, enforcers in the courts have looked at how consumers can be harmed through anti-competitive mergers and anti-competitive conduct. And in the digital ecosystem world, obviously, consumers pay with their attention, they pay with their information, but they're still paying. That is the metric of exchange. You don't have to have a price. You can have what we call zero price markets, where consumers pay through different channels. And that is as important, if not more important, than looking at price effects.
So why is consumers' data so, valuable to big tech?
If you just talk about how much data is available, they can use that information in so many different ways to market, to steer us towards particular products. And if you think about an overall business model, if you have a website, platform, set of services, you want to keep consumers on your platform, on your, working with your services as long as possible. And so that means really targeting them in very strategic ways. It means manipulating them and making sure that they get to your sites and stay in your areas. And so data really allows a company or companies to really do that effectively and really market to you, which in the end really does manipulate the consumer and push them in ways that just doesn't happen in a, traditional marketplace when you're walking down the street. When you're walking down the street, there isn't suddenly a barrier in front of a store and you can't actually see what's there, or suddenly magically 3 parking spots open up in front of one store and suddenly a bunch of cars appear in front of another one. That just doesn't happen in a traditional street setting. But that sort of stuff can really happen when you're in the technology world, and that data, it's a lot of data, and it's not just you, it's your friends, it's folks who are like you, and it really allows them to predict what you're interested in, what will keep your attention, what will keep you coming back and buying more. So the data is very important to their business model.
Yeah, I think the digital, I call it the digital ecosystem business model. I think people are beginning to understand, especially now with big tech getting so much attention in the media and with cases filed. It really is a very unique business model, and it has a very unique value proposition behind it. And it's all centered on data, right? Data's the fuel, the grease, the whatever you want to call it, that holds the ecosystem together and ensures connectivity across all of the interconnected markets in the ecosystem. That's very different than sort of traditional manufacturing distribution models where you have horizontal integration, you have vertical integration. These are very different animals. And as I said, they really center on data collection, but also the enrichment of data through artificial intelligence, data analytics, machine learning. And the whole value proposition is to not only collect data, but to enrich and enhance data so that the ecosystem can guide the user, through the user engagement, through the ecosystem. And the way they do that is through what we call in economics preference shaping. Most businesses accommodate preferences of consumers. They say, okay, you want this, and we're going to give it to you. The digital ecosystems do quite the opposite. They say, look, we've got all your data, we're enriching your data, and we're going to create algorithms that recommend things to you. And that's what we call data preference shaping. It's a very, very different mode of operation. But the reason why it's important for these antitrust cases is because it does put data, really, in the crosshairs. And because it's so valuable, the platforms have every incentive to violate users' privacy, to suggest new services and products to them. And because we don't have good privacy laws or a good construct around privacy in the United States, this kind of makes for a toxic mess for consumers, almost to the point where consumers are saying that they have certain privacy preferences, But marketing research has actually shown that consumers are making decisions that completely violate their privacy preferences in the ecosystems.
Yeah, it's really hard for a consumer to know how to control their information, their privacy. I mean, it's very difficult. It's made very, very difficult.
So I want to follow up on two things. One, I'd be interested, Diana, if you could explain a little more what you mean by data enrichment. And two, if either of you could expand also on, how consumers are acting against what their express preferences are.
Sure. So, as I said, there's raw data. There is huge capability for the ecosystems to collect data because consumers are providing information about themselves as they engage with the ecosystems. I mean, raw data is useful, but it's not nearly as useful as enriched data. So, I've done a lot of research on acquisitions by the big five digital ecosystems. And what we found a few years ago was they were out very quietly acquiring data analytics assets, artificial intelligence assets, machine learning assets, all of the pieces and parts of the, and these are discrete markets, that would enable them to take raw data and to process it and create these, these algorithmic recommendations. For example, Google acquired Looker a few years ago. And AAI wrote a letter to the US Department of Justice Antitrust Division saying, hey, you guys should be looking at this. Amazon has 32% of the market in data, data analytics and web cloud computing, and then comes Microsoft with their Azure suite, and Google really wanted to increase their position in those cloud computing markets. Those are really critical markets. Without that capability, you can have all the data in the world and not be able to do much with it. And so that competency has been dramatically ramped up by the digital ecosystems over the last few years, but it is absolutely critical for them to realize the value of their digital ecosystem, their digital ecosystems, and keep users engaged in a way that maximizes, maximizes their profits across the entire collection of markets in the ecosystem.
They also have the ability to just make it harder for other companies to compete. I mean, it's very frustrating to see. This is not just a consumer challenge, but it's a challenge for anyone who's trying to innovate and come into this marketplace. A lot of times these tech companies, not only do they control the avenue by which we're walking down to shop, but they also then own some of the shops. And it's really easy for them to ensure that you're seeing those shops. They have oftentimes bought up some of the companies that are selling the advertising, the things that determine what we see. And they have algorithms that make it so it's not interoperable. So other companies can't necessarily use it or use it as effectively. And so it just gives them a leg up. And yet, one more way where we're not being able to see what is out there, and other companies are not able to compete in the marketplace. We don't have as much choice. There isn't as much innovation, and prices can go up.
And I think it's really important to add that, these ecosystems have some really unique properties. There are what we call network effects, which is the value of the engagement increases dramatically as more people sort of users join the network. We have things called winner take all markets, where the winner tips very, very quickly to a single provider. All of these very unique features play directly into the antitrust implications for not only for digital ecosystems and acquiring additional assets, but in terms of their conduct, how they conduct themselves. Not only in terms of making it difficult for rivals to enter the market and incentives to squeeze out rivals, but also to keep consumers, as Danny so well said, keep consumers locked in that ecosystem, and to prevent them from sort of multi-homing across other ecosystems that might, be providing similar services.
And could you explain a little bit what you mean by multi-homing? That may be a term of art that not everyone knows.
Yeah, multi-homing is just the ability to go to different sources or sellers that share very similar characteristics, but might be offering slightly different experiences, right? So, for example, if you're looking for personal social networking, and obviously Facebook is one option. Twitter is another option. You can obtain that value through different services. Multi-homing is actually a good thing. You want consumers to have choice to be able to, get the value that they want. But when you have these ecosystems growing so large and dominant, and making it difficult for rivals to compete effectively, then consumers lose that multi-homing capability.
So we've mentioned innovation several times today. We were talking about non-price effects that can be examined. Diana, this may go to you first, but does antitrust law take into consideration, the impact on innovation? I think because we would often hear an argument, well, these companies are being really innovative, they have new products and services. How does antitrust law consider that?
Yeah, so antitrust law, absolutely. It is totally in the wheelhouse to look at effects of mergers and what we call exclusionary conduct designed to keep out rivalry, not only on prices, but on quality and on innovation. And we have had actually a couple of cases where the antitrust authorities have been concerned that a merger, for example, would eliminate competition, for example, in research and development. Obviously, you need R&D to be able to innovate new products, bring them to market faster, that sort of thing. I think the important thing here is that we don't often see those that concern stated as a standalone case in antitrust. We often see concerns over harm to innovation because of a loss of competition. We see those attached to other concerns like, well, prices are going to go up or quality is going to go down. And so we always say that innovation is often attached, or it's sort of a side thought to effects on prices and effects on quality. I think what these cases, the state cases and the federal cases, are going to be demonstrating is that harm to innovation is exceedingly important, and the spotlight really needs to be on it. And I think these cases will really support the ability of enforcers in the future to bring more cases that are where the claim is, look, innovation is really going to be harmed by this kind of conduct. So these cases are absolutely going in the right direction and supporting that.
And I think if you just look at history, I mean, I was a history major, so I always look back, and it just, the times when we see big technological breakthroughs and big advancements, those are marketplaces that are very competitive. I mean, that's, innovation is there when you see lots of different companies competing and coming up with new ideas and advancing the ball. So history just shows us that competition leads to innovation, choice, and leads to innovation.
Privacy component fit into these antitrust cases against big tech?
Dan, you want to start on that one?
Go ahead. Oh, I can follow, no problem.
So privacy, to me, I mean, part of the challenge is that for consumers, I mean, certainly speaking for myself, it's hard to feel like you have any control over your information right now because you don't have very much choice. Most of the ways that you're allowed to participate in these new marketplaces is a take it or leave it strategy. So, these are, if you want to participate, then we get your data and we can watch and track you. And if you don't, then if you don't want to do that, then you don't get to participate. So a very take it or leave it. And so you're really, and for a lot of us, we don't even know the full extent of what our data is being used for. I mean, once your information gets out there, and we talk about this in the data breach context, identity theft, when we hear about those big data breaches, once your information gets out there, it's out there. And it's scary enough to think that someone took it from some company, but it's actually even more worrisome for me to know that there's a company that's taken it from me and then given it to somebody else and given it to somebody else and given it, because that's just their business model. And I didn't really have any say in that. I didn't have an explanation for it. I think of my grandfather. So my grandfather lived into the 90s. We would visit him every year in Sarasota. And he had one restaurant that he would go to every morning. So for a week, every morning we go to this one restaurant, and he'd walk in and every waitress would know who he was and what he would order. They would know who I was because he would tell them stories about me. It was a really nice environment. It was lovely to visit. But what I knew wasn't going to happen is that the waitresses and others in the restaurant were going to pick up a phone and then call the restaurants in my town and tell them all about me and what I like to order and who I am. And when I got home, all of a sudden I'd start getting these personal marketing. Oh, we heard from Sarasota that you like that, and that's just one step removed. That's just one restaurant calling another restaurant. And I'm sure my grandfather would not have wanted that, even though he was a talkative guy. He still, you have some sense of control of your information, who you're telling what to. But in this digital marketplace, in this world, once your information is out to one person, the business model is such that it's then shared with dozens and dozens and dozens. And you don't get a little list that says, would you like your medical history or your age or your gender or whatever it may be shared with? And then they just have a long list. You don't get that. You get some very lengthy information, oftentimes incomprehensible to people about different partners and different situations, and you get options to maybe share in this case, in that case, and it's hard, it's confusing. And once your information is out there, you can't pull it back in because now it's being shared all over the place. So privacy is very important, and it's very much wrapped up in this monopolistic system or oligopolistic system, because you don't have choice, you don't have options. It's take it or leave it. You give us your info or you don't, and your info could go in any number of different directions.
Yeah, Danny put it quite well. Just to add a little bit of dimension and depth to that, privacy enters the whole equation on competition in the digital ecosystems kind of through the quality channel. We've talked a lot already about harm to consumers based on pricing, quality, innovation, choice, all these important things. My view is it enters through the quality channel. So users engage with the digital ecosystems, they provide information, they give their attention. And Danny's absolutely right. They have no idea how much information they're giving and how that information is going to be processed and then fed back to them through these algorithmic recommendations. Degradation of violation of privacy, which the digital ecosystems have every incentive to do because it's so central to their business model and their value proposition, is is sort of the major problem. And so when you degrade consumers' privacy and you abuse their privacy, you are basically giving them a much lower quality experience in these markets, in the digital ecosystem. So that's number one. There are strong incentives to violate privacy just to realize the value proposition in the digital ecosystems. It's also true that there's a huge misalignment, as I said earlier, between what consumers think they want in terms of privacy protection and what they actually do through their actions. Consumers will say, oh yeah, I really value my privacy a lot. But then when they engage with the digital ecosystems, they end up giving, information that absolutely can be used to degrade their privacy. And then third, I think we have to remember that, just a little bit of data in these digital ecosystems can go a long way. They can take a segment of users with a certain profile, and then they can extrapolate based on those characteristics and user patterns to a much broader to a much broader audience. And so data is central. Violation of privacy is central to the ecosystems. And of course, the problem is, we don't have any social regulation in the US to speak of around data and privacy. And so I think that is creating a tension in parallel to these antitrust cases and what's coming out from them. And it's sort of highlighting that when we do get to remedy, how to fix these competitive problems and how to protect consumers, is antitrust going to be the sole, the only tool to do this? Or are we going to need to kind of set up in parallel a better regime to protect consumers and their privacy?
And I just want to emphasize too, again, we've talked about consumers, and I think people think of individuals like me or you, but it's also the folks who are trying to compete on these platforms as well, their privacy. I mean, to the extent that they're trying to sell a product in a particular way on these platforms, they oftentimes are being watched as they're selling them, and the information about the price and who's buying it and what is then being used to then create another product that's going to compete with theirs or maybe undercut theirs. And so this can be really challenging. This privacy component also goes for those who are trying to compete in this marketplace as well, not just for those of us who are the buyers, but it's also the sellers as well who can be taken advantage of. And again, that can really squash the innovation that we want to see in any marketplace.
And there is competition on privacy, which is a dimension of quality. And because there is competition on privacy, we know that's evidence that competitors, rivals are very aware that some users value their privacy. So, for example, Bing, one of their goals is to create a more secure user experience. DuckDuckGo, for example, is another example of that. And we've been tracking really closely, how competition on that merit, providing higher quality through better protection of data and privacy, how that is getting traction in the digital ecosystem world. But the fact that rivals are doing it and they see it as a dimension of competition is really, really important. It supports the whole notion that quality and privacy are really important to consumers, and antitrust enforcers clearly have recognized that in these cases.
So Diana, you've mentioned that privacy is a dimension of quality or enters through the quality channel. So just so people can kind of understand, if there are allegations that a company has violated your privacy, is that in itself a violation of the antitrust laws, or is it something else that's considered?
Yeah, so very good question, good technical question on a monopolization case, basically. But monopolization law in the United States basically addresses conduct by a large or dominant player that is designed to squeeze out rivals. And by squeezing out rivals through any variety of means, you can reinforce a dominant position, and you can then really rip off consumers, even relative to being in a more competitive market. So the challenge in an antitrust case is to explain not only how through their conduct, the dominant player squeezed out rivalry. And for example, in the Facebook case, we see that come through in a variety of ways. For example, acquiring smaller rivals like Instagram and WhatsApp and that sort of thing. But also through as that sort of filters down through the consumer experience, this lack of competition provides stronger incentives to violate, to degrade quality and to violate consumers' privacy. So the cases are constructed in a way, a very, very careful and compelling way to sort of build that story, to create that story. Tracing all the way from how the digital ecosystems have excluded rivals and how that sort of trickles down or filters down to the consumer level in terms of degraded user experience. So and that is very unique. I don't know how much people realize how unique these cases are, but they are well within the ambit of how past monopolization cases have been framed in the US. For example, Microsoft and AT&T, and we don't have that many monopolization cases to refer to.
So we touched a little bit on remedies, and what do we do now with everything that we have? Danny, do you want to talk to a little bit about that? There have been calls at sort of the national level of breaking up big tech. What does that mean? Would that actually restore competition? Would we see a difference?
Yeah, a couple of things that I would say. I mean, first off, we want to make sure that states can continue to be first responders. I mean, Attorney General Weiser and other attorney generals around the country, we want to make sure that they continue to have the ability to do what they are doing, which is hold companies accountable, protect us against fraud and deception, and also go after any of these monopolies, oligopolies, and really ensure that we have an innovative, competitive marketplace that consumers, are not being harmed on. So, just ensuring. So often when we hear solutions, sometimes we start going down the path of, well, we need a national solution, and that means that states are not allowed to step in. And I think it's really important that we continue to ensure states can be first responders, and that leaders like Attorney General Weiser can continue to do what he's been doing. So that, I think, is kind of top of mind. I also talked about this earlier. I mean, I called it, sloppy antitrust enforcement. I mean, making sure that we are using the full breadth of the law, and knowing that, especially when it comes to technology, it's not just about price and saying, oh, in the technology space, so much of this is free to consumers, so there isn't a problem. There is a problem. There isn't choice. There isn't innovation. And so ensuring that we are, fully bringing forward the actions that need to come, on a federal level, on a state level as well. And I think there is more that states can do to help protect consumer privacy and data and rights. We've started to see some states take action, but frankly, it's just getting more to a world where I, as a consumer, have a better sense and actual control over how my data is being used. The ability to say, no, I do not want to share this information. I don't want this to get out there or shared with any partners or anyone else. And doing more, maybe even going so far as to have some sort of opt-in system. So, you're joining this program. Would you like to share it with this? Would you like to share, would you like to be tracked in this way? Would you, just actually opting in? And I think if we had a system like that, we'd all be a lot more aware of what is going on behind the scenes. And I think that would be better for consumers and also better for the marketplace as well. Some people might not mind, sharing those things, but to actually have a opt-ins or a better understanding of how this stuff is used is going to be important for consumers. So those are some of the things top of mind for me.
Yeah, I have some big questions that I am still sorting through, and we at AAI are sorting through on what will make for an effective remedy. And I'm, we're heartened to see the state and federal complaints kind of leave the door open on how to fix these competitive problems and to restore competition in these markets. And we always think about remedies in two buckets. One is what we call a structural remedy, and that's basically forcing a firm to divest itself of assets to reduce their market share, reduce their market power, and prevent harm from occurring in the future. And then, of course, the other bucket consists of sort of rules and regulations about how those firms can conduct themselves in the market. They're very, very different types of remedies. I think it's worth thinking about, well, what would a breakup do if we broke up some of these digital ecosystems? So go back to Standard Oil, go back to AT&T. The AT&T case we ended up with 7 baby bells telecommunications companies. We now know that AT&T has done everything in its power to regain its monopoly through the last many decades of acquisitions, and that's an interesting factoid that people should put kind of an exclamation point by. My concern with the breakups is that really going to work, given that these digital platforms are sort of fundamentally winner-take-all markets. We have these very strong network effects. Oh, you got to be on this platform because everybody else is on that platform, and that increases the value of my experience. If we break that up, given those sort of fundamental economic characteristics, what will prevent those platforms from regaining and rebuilding their dominance in those markets? So new technology may come along that displaces this current crop or generation of digital ecosystems. Or maybe the better word is to eclipse them. They won't actually displace them. But I have real concerns and questions about, if you were to break up Google, for example, into a smaller set of companies, what would prevent any one of those from regaining significant market dominance while other ones just failed completely? And so I think when we go to the question of remedy, we have to ask ourselves, well, what is it about the digital ecosystems that allows them to gain and to maintain their market power? And it is the data. It is the consumer data. It is the ability of the platform to enrich that data as we've talked about. And I think any remedy that's going to be effective and restore competition is going to have to address the data. And Danny, raised some really good points. We don't have any privacy protection in this country to speak of. So we may end up with a system where, for example, we create more granularity in how consumers can opt in or opt out. Instead of, well, I opt in, I opt out, it may be 5 different levels of privacy. Or we may have more a market-based system where consumers either pay to get higher levels of privacy protection, or the digital ecosystems pay the consumers and the users for that. But I don't think you can talk about breakups and expect that to fix the problem, while ignoring the role of data and data processing and enrichment in making these digital ecosystems work.
Okay, well, I do want to allow a little bit of time for questions. So we already have a few in the Q&A, and if there are others that want to put in a question, please do so. So one of the questions we have is, how do we get companies to only require the bare minimum of consumer data to make their decisions? So given as an example, talking about a bank, getting all this PII to make a refi decision and then holding on to it for a number of years.
Danny, you want to try that one?
Let me think about that. Why don't, if you have an answer, dive on in.
Hazel, can you restate sort of the nugget of that question?
Yeah, so how do we get companies to only require the bare minimum of consumer data to make their decisions?
Okay.
So basically saying, yeah, where they only acquire, what they absolutely need.
Right. Well, that is really a tough one. Wow. Because data is so central to the value proposition, that goes against everything that a digital ecosystem would be interested in doing. So not only that, as a remedy, in terms of sort of a regulation of the platforms, that is going to create an enormous amount of involvement by sort of a sector regulator in the business and the workings of the digital ecosystem. So that sort of tease up what would be a pretty significant regulatory regime where there are directives coming from a sector regulator. This is what you will do. This is what you cannot do. This is what you need. This is what you don't need. And that I'm not sure how much traction that will get in a bipartisan world in terms of remedy. But it's a really good question because it illustrates the very snarly issues that are raised by the role of data in the ecosystems.
The thing that pops into my head with that question is I feel like, again, when you're in a physical world, when you're in the physical environment, you're walking down the street and you walk into a store, they usually don't know anything about you when you walk into the store. So there's already, I guess, examples of worlds in which people can buy and sell without knowing the specifics about who you are, without being able to predict what you're interested in, without being able to sort of market to you in any specific way. So we have examples of that. On the digital world, I agree with Diana. I mean, it's kind of counter to the business model or to how they have had success to limit that data. I go back to kind of personal preference and giving the consumers more power in this situation, and those other businesses that are trying to compete in those marketplaces, and just allowing consumers to control their information more and make informed decisions about how much they want to share, and in return they get a more a select view of things. I think it's one of the TV streaming services. They kind of know what we watch, so they predict what we would be into, and they kind of push those things to us. And we had an option to opt into that. You could opt out of that and you just see whatever the heck is new. You had an option to do that. But I think what's frustrating is, while they gave me an option to do that, they probably didn't give me an option to control my data so it wouldn't be shared with other parties and other advertisers who are then kind of pushing things at me in other spheres. And so I go back to one of the solutions here, I think, is just giving consumers more power and more choice, to decide whether they want to provide more of that information and get something in return or not. And I just don't think we really have that real choice right now. And I think providing that more could be a solution in this situation.
I also think that, proposals like data portability, where consumers can take their data with them, data open access regimes, where there's some attempt to allow transferability or more transparency about the use of consumer data in these ecosystems. Those proposals have popped up as well. But again, though those types of things would necessarily have to be part of a very broad, very almost invasive regulatory regime involving the digital ecosystems, which of course they would fight tooth and nail, because data is so important to them, and their ability to maintain their market power, to differentiate their ecosystem from others is really central to their survival in these markets.
And I think privacy is important to us and central to us. So, that's an important part of this.
Thank you. So the next question we have is, large companies have historically sought to implement and maintain legal monopolies by seeking government regulation. And so the question is about Facebook. Please comment on the dangers of creating a legal Facebook monopoly and how regulation may eliminate competition.
Right. That's, yeah, these are good questions. They're hard questions too. I don't profess to have all the answers. And I'm a former federal regulator, but I did that in electricity, where, we were dealing with electrons and generators and transmission lines and that sort of thing. So yes, I think, regulatory, we call it regulatory capture, where basically the industry gets the regulation that they want, because that will allow them to, to do what they want and in seeking, to maximize their profits. I think it's a bit of a double-edged sword. The platforms are smart enough to realize that they need to engage in this conversation sooner rather than later. Otherwise, they're going to get regulation handed to them that they may not like. They may also get regulation handed to them that is not particularly well informed by the engineering of the digital ecosystems, the business model of the ecosystems. So it is possible that if they don't engage in a collaborative way, they will get regulation that really misses the mark. And believe me, it's happened before in other sectors. So I think that actually it is not a bad idea for, to create this conversation, knowing that regulation is likely coming, to create a conversation so that regulation does what it's supposed to do. I think what you don't want to have happen is for the companies to influence that dialogue to the point where regulation really turns out to be ineffective and misses the mark completely. So it is a very double-edged kind of sword.
And I would just add in, I think it's important in this conversation to continue to ensure that states have the ability to act, both attorney generals and state, other regulatory or legislative bodies. That just like we talked about competition, when you have federal standards and the states can't do anything, it can breed this lack of innovation or lack of protections. And so I recognize that there can be a challenge for companies to have what they oftentimes call a patchwork of regulations around the country. But I also recognize that one way to avoid a federal rubric that then can kind of squash some of the things that we need to see is ensuring that states can continue to move the ball forward and rely on, reasoned debate, such that if there is some state that's going to do something that will really undermine it, that you can have that debate in the public sphere and not just rely on some federal law that stops any state from doing any sort of innovation. We know this world is constantly changing, and so to ensure that states continue to be first responders, I think, is really important.
And I think there's some really good analogies to what to illustrate what Danny is saying. So in other areas outside of digital tech, we've seen state legislative initiatives that appear really consistent and coherent across the states. For example, to deal with transferability of tickets. This goes to the whole Ticketmaster thing, where you can't transfer your tickets electronically to another user, and that squeezes out the secondary ticket sellers. We've also seen state efforts, a lot of consistency in curbing the powers of the pharmacy benefit managers, for example. There's a big, collaborative initiative on that. I could see something like that definitely popping up in the digital, tech world as we address these types of issues. There should be lots of coordination.
Well, so we have several, great questions, and we're not going to be able to get to all of them, but I do have one more I want to ask if we can give quick responses, because I don't think we've gone into this today. And that is, Europe seems to have managed this. Is there a way to follow their lead and require notification on who your data is being used?
Diana,
Yeah,
I look at you at this one.
Yeah, I think we have and should continue to learn a lot from the European experience on digital markets regulation. I think the Europeans' approach to the antitrust cases is another story. Those cases have been going on for years and years, and they're in this sort of endless dialogue with the companies about, well, what remedies do you want? And so that's a very different example than what's going on in the digital market regulation side. They've made a lot of progress over there. There are a lot of good ideas that we should be thinking about.
And I guess I just say, as long as we all have our eye on the same goal, then I think we can get there. It's about having marketplaces that provide consumers choice, that provide innovation, that allow other competitors to come on and compete on the quality of their products. That if we have our eye on that, and also that people should be allowed to keep private what they want to keep private and have control over their information, which is extremely valuable. That if we all agree that that's the goal, then we can get there. We can find the right regulatory and other consumer protections to get there.
Well, on that note, thank you both, Danny and Diana, for the robust discussion today. It was a lot of fun. And, as we saw from the Q&A, people are very interested in this topic, and we could go on, I'm sure, for hours. So thank you. And we'll switch over to our next panel.
Great. Thank you. And thanks for the leadership from the Attorney Generals across the state. Very appreciated.
Thank you.
Okay, Generals Weiser and Peterson, are we ready to go?
Ready to rock and roll.
We're ready.
Great. So we're going to our second fireside chat. We have Attorney General Phil Weiser and Attorney General Doug Peterson of the state of Nebraska. So I'll do short introductions before we get into it. So Attorney General Weiser, he serves as Colorado's 39th Attorney General. General Weiser has many accolades, as you may know, but I'll give some highlights that are particularly relevant for this discussion today. General Weiser has served at the U.S. Department of Justice under 2 administrations, first as senior counsel to the Assistant Attorney General for Antitrust, advising on telecommunications matters during President Bill Clinton's administration, and second as Deputy Assistant Attorney General in the Antitrust Division under President Obama's administration. He also served on President Obama's transition team, overseeing the Federal Trade Commission, and is a senior advisor for the technology and innovation on the National Economic Council. So Attorney General Doug Peterson, he was elected Nebraska's 32nd Attorney General in 2014. General Peterson has been a strong advocate of consumers during his time and advanced a number of consumer education initiatives, including one focused on digital citizenship, promoting the safe, responsible, and respectful use of today's information technology. General Peterson also filed the first HIPAA-related data breach case against Medical Informatics Engineering and No More Clipboard with a group of other attorneys general, resulting in a significant settlement. General Peterson co-chairs the National Association of Attorneys General Antitrust Committee, of which General Weiser is also a member, an organization that facilitates the work of attorneys general in enforcing state and federal antitrust laws. I also just want to say on a personal note, I've had the privilege of working with both General Peterson and General Weiser, and they are just great people who care a lot about the consumers of their respective states. So let's get going. We have here today 2 attorneys general of the state of Colorado and Nebraska, and I'm curious, have Colorado and Nebraska worked together before? What is that relationship?
Well, maybe I'll go first. when I first came into office in January 2015, I inherited a lawsuit against Colorado related to marijuana. And at that time, Cynthia Kaufman was the Attorney General. And actually, I think Nebraska and Colorado have had a very good working relationship. One that's kind of based upon a mutual respect and just an ability to work well together. So we developed initially that relationship with General Kaufman, and then when Phil came on board, I think Phil and I first met walking to dinner with a bunch of other new AGs in Charleston, or maybe it was, I can't remember.
It was Charleston, but you had called me before that. So Doug was one of the first people who congratulated me on winning. And he said, there's a lot of conversation about the importance of antitrust in technology markets. I understand you've got a background in this area. And that was like November of 2018.
There was the bond, right? See, because I got a 67 in antitrust law, and I needed someone who really understood antitrust law, so I called Phil. No, but that's where we first got engaged in the discussion, and the working relationship has been very good. Gotten to know you, Diane, and others in the office, and we've worked closely, both in the investigation and now moving forward. So I would say, frankly, Phil and I are probably on the phone with one another at least weekly, if not more than that. And so it's been a very good working relationship.
Well, let me underscore something that is not often appreciated, but Doug's not just the leader of this effort. Doug has rolled up his sleeves. And so with Doug, it's a twofer. You both have the sort of leadership at the policy level, at the principal level, but you've also got a very talented lawyer who is deeply engaged in the both tactical and strategic decisions. And so when we think about the team of lawyers working on this case, I would include Doug Peterson on that list.
Thanks, Phil.
So diving into sort of the cases and the reason we're here, Colorado and Nebraska have played key roles in the recently filed cases against Google and Facebook. How did Colorado and Nebraska start working together on these investigations?
You want to go first, Phil?
Well, so there was that first phone call, and then there was the visit in Charleston. And Doug had been in these conversations before I was elected, and he can give the backstory. I then joined, and over essentially 2019, these conversations were taking shape, which is there was a recognition that in the world of big tech, companies like Google and Facebook notably clearly had monopoly power. And the question was going to be, are we concerned that they've abused that power in violation of the antitrust laws? And that's something that I know a lot of the consumers and companies in Colorado, as the first panel captured, were concerned about. So this is something I was aware of, but I would say I give Doug extraordinary credit for a lot of the spade work. If people are ever looking for a diplomat, I would recommend Doug with the highest recommendation, because working across state AG's offices takes special diplomacy skill. And so Doug was putting in a lot of that effort, having conversations, who's interested in this? And I believe it was formally announced in September of 2019, but between January, and as I mentioned, even November the prior year, there was a lot of those informal conversations happening, so that when we got started, it wasn't coming from a flat start. There had been some real thinking and work had gone on, and there also had been a lot of coordination, so that when this was announced, Doug will remember the numbers, but it was a overwhelming bipartisan commitment in both these cases. And Doug and I were both raising our hand to be on the executive committee of both the Google and the Facebook case.
Yeah, and what I would, looking back on history, what I would add to that is back to the summer of 2018, there'd been a lot of discussion nationally, internationally, because we saw what was going on with the European Commission looking into Google's the fines that they had done. And there'd been a lot of discussion about big tech growing and whether or not it was creating some real competition issues. And so as we were going into 2018, it was actually some discussions among a couple of AG offices. And typically within the state AG offices, what you'll see is antitrust is developed among antitrust specialists within the office, and then it's presented to the AG and recommendations are made. And what was unique about this one is there were a few of us who were just very interested and concerned. And I come back from a 25-year trial litigation experience, so it was just naturally kind of really tapping into my own litigation experience or concerns. And so what really became encouraging is that when Phil came on board, he provided that type of expertise to help us evaluate it. The experience that Phil had at the Department of Justice and just his knowledge of technology really took it to the next level, where I finally felt confident that we had some really strong AG leadership going forward. So what would be somewhat unique about both these two cases is that I think started out with AG awareness and then working with staff and building that up, as opposed to AG antitrust staff building it up and then bringing it to AGs. This one has been unique, in fact, that it's had such a strong AG leadership, but I don't think we could be nearly as far along as we are without Phil's expertise and leadership and the ability to work in a bipartisan way on all of this.
If I could add a couple points, Tom Miller, who was here during the Microsoft case, has really appreciated, and just for those who are thinking about this, we've done this during now a course of change administrations in a difficult political environment and have kept a strong bipartisan commitment going. And the staffs that have worked together across these offices deserve great credit, starting with you, Diane. The work you've done in our office has been truly exceptional, as Steve Kaufman, the head of our consumer protection, and I know Doug's team has been just a great to work with. So that partnership has gone up and down. I also have to acknowledge something unique. Two friends of mine who I knew from past government service, John Sallet and Jeff Blattner, agreed to come on board as executives in residence, not taking a salary during these investigations. And they each served as deputy assistant attorney generals at the Department of Justice Antitrust Division, as did I. And they, because of their commitment to serve, wanted to support the work that we're doing. That's something that I don't know if states have taken advantage of before. I predict when people look back at these cases, both of their contributions will be appreciated, because one of the concerns I had going into this is sometimes seasoned antitrust observers, sometimes the federal government, don't always take the states seriously. The states are viewed as sometimes just hangers on to what the federal government is doing. And I have been committed as Colorado's Attorney General to take action in the antitrust area because we have the capacity, we have the commitment and concern. And I know Doug shares that same point of view. And I believe in these cases, which are super important cases, we are producing high quality work product that will demand respect and attention.
Yeah, and if I can give a shout out to John Sallet. If I talk to Phil once a week, I talk to John twice a day. And that's probably because John and I appreciate one another's sense of humor, and we're apparently the only ones who do, because when we're on these conference calls, we're only laughing at each other's jokes. But John has been such an asset that Phil brought on board. It's hard to describe how much work he's put in. And I know, Diane, you work closely with him also, and he's just a real, number one, excellent mind for antitrust, really knows where we need to go. Very courteous, but really a strong asset to what we're trying to do. And I appreciate Phil having the wisdom to bring John in to do that, because we really needed his leadership, his experience in leadership. He's a really old guy, so that really helps.
Well, this is an important opportunity that I would say, frankly, for public and private sector entities. My theory of the case coming in as Attorney General was that two talent pools are underutilized. People with experience who maybe retired or otherwise underemployed, and lawyers early in their careers, even interns or fellows. And Diane has embraced this in her leadership role, both in the sort of up and coming and in the seasoned veterans. So in addition to both Jeff Blattner and John Sallet, about a year ago, we also announced Bob Hill, who formerly held the job that Steve Kaufman now has, the consumer protection chief here. Bob had a great career. And what I would say all three of them have in common is they all care about mentoring, teaching. And part of what I want the experience of lawyers in our office to be is learning from the best and bringing in super high quality people. Now, if you look at the top leadership that we have, people like Natalie Hanlon-Lay, our chief deputy, saw earlier, Eric Olson, our solicitor general, Eric Meyer, our chief operating officer. These are people who are at the top of their game with that mentoring mindset. And that's a key part of what our office is about. And I know Doug and his team has brought in lawyers early in their career to give them a chance to work on these cases and to show what they can do. Diane, to ask you a question, you're on the receiving end of this experience. How would you talk about the type of team and the type of mentoring that we're working on? Is that something that you think there's a lesson or two to be learned from?
So this office has been very focused on mentoring and kind of even recycled the way we do coaching and performance. And I like the focus on helping, those in the office look at what their goals are, and then, through both formal and informal channels, helping them achieve those goals. And I have had the benefit of getting to work with all three individuals that have been mentioned, Bob Hill, Jeff Blattner, and John Sallet. And they have been mentors to me. And I feel incredibly privileged to have learned from them. And each of them has unique skills and experiences that they bring and that I'm learning from and that they're sharing with our office. So. And one of the things that I will say about John as we were complimenting him, what I like the most is when he calls me, which he does several times a day, he always starts out with, "How are you?" And it's a genuine question. He wants to know how I'm doing. So I think especially during these times, it's just really refreshing. But I did want to, unless did I answer your question, AG Weiser? I want to go back. You both have mentioned that, the bipartisan nature of both Google and Facebook. And I'm curious, is that the norm for these multi-state antitrust cases, that they're bipartisan and how they work?
I really do think within consumer protection and antitrust, they very much naturally provide a bipartisan effect because they're consumer oriented. It doesn't really matter whether the consumer is Republican, Democrat, Independent. I mean, we see our consumers being affected by either antitrust, anti-competitive behaviors, or some type of consumer fraud or deception. So it's very easy, whether that's coming together on the drug issue, coming together on different classic consumer protection issues. This one, as you see, so many states, both in the Facebook and the Google matter, were willing to join because I think they all had significant concerns about privacy and the amount of data being accumulated. So I think what creates the support for a bipartisan effort is staying focused on the facts and the law. I know that Phil will take a position in this new administration that I will disagree with on some particular issue, and he'll see that I joined some Republican AGs. But what's interesting is in our working relationship, it always comes back to what we're doing in this particular case. And because we've built trust in that working relationship, we stay focused on that, stay focused on mission. And it makes it very easy when we do that to keep partisanship out of the equation.
I could go on this topic for a long time, Diane. The level of polarization that is taking place in our nation right now is a threat, because if you displace collaborative problem solving and you escalate demonization based on how you label somebody, you undermine the whole project of governance and democratic republicanism or self-governance. And what is important about relationships between state AGs on these consumer protection cases is they build that trust, respect, shared collaboration to protect consumers. So antitrust, we'll talk about a lot today. It's important that Doug mentioned opioids because there's a lot of work happening in that area. I'd add another one, which is consumer protection around airlines, where General Mark Bernovich and I, who just did a similar fireside chat on federalism, which is a shared commitment we both have that's across party lines. We work together to get state AG's authority overseeing misconduct by companies like Frontier, who haven't followed through on their commitments to consumers. And that's because I don't care. It's not like I'm a Democratic consumer, I'm a Republican consumer. I think Doug said it really well. I'm a consumer and I deserve to be treated fairly by the rules. And that's something that transcends party lines. The one final point I will get to, a result of the building of confidence, of trust and collaboration is you can find ways to talk to one another about other issues where you may disagree, just the way Scalia and Ginsburg were able to do. And we need to get better at that in our nation. The other benefit is you can find a way forward on difficult issues. So Doug and I led a joint letter. We had 50 total AGs, including territorial AGs, sign condemning the attack on the Capitol and calling for accountability. And that was an important statement that got made across party lines, and relationships built up in these contexts help facilitate those sort of actions.
So talking about the Google and Facebook cases, there, for example, in Google, there were 38 attorneys general from states and territory who were a part of that complaint. But there are also, a few months before the states filed, the Department of Justice filed with a few other states prior complaint against Google. And with Facebook, the Federal Trade Commission also filed its own complaint against Facebook. So my question is really two parts. One, how do the states all work together on these multi-state investigations and litigation? And two, how do the states work with their federal counterparts on these matters? It seems like there's a lot of cooks in the kitchen.
In the antitrust group, both with Facebook and with Google, you developed the executive committee, as you know, Diane, your participation in that. They are the managing operators. They basically keep the ball moving, assign tasks, look to develop those who can help support the investigation. So in that way, you have these core committees are really what drive the effort. For example, in Google, you had Iowa, Colorado, Nebraska, Tennessee, North Carolina, Utah. Those were the primary states. And then on the committee, you had New York was also part of it, and Texas was part of the committee. I'm missing a couple, but anyway, those states, again, were focused on what needed to be done in an investigation. And it's like any lawsuit, you get so focused on developing your facts that it becomes very easy to work well together and stay focused on the issue. And then from an AG standpoint, we also stayed in communication once a month with the core committee AGs, which was a helpful way to make sure that it stayed front of mind that this investigation get completed. I'll jump over just a little bit to your other question, Diane, with regards to working with federal agencies. But one of the challenges in the Google case is that we knew the Department of Justice had started their investigation approximately 2 to 3 months in front of ours. And so they were running on a little bit quicker timeline, and there was always this balancing because we wanted to maintain, and this is very important to Phil and I, that we wanted to build this out from the very beginning as a multi-state antitrust investigation. And we weren't going to rely or depend upon the federal agency to do any work that we felt we were responsible for doing. So we wanted to always maintain that independent focus. And that has really helped us because frankly, when you're out developing your own factual information, having your own dialogue with third-party witnesses and experts, you then know that regardless of what happens on the federal level, the states are prepared to do the multi-state. And I don't know historically if that's been the model. But I know Phil very early on was saying it's important that we do that. And Phil, having his experience with DOJ in the past, I think really carried some weight and insight to us of how important this was, to never get to a point where we say, well, the feds will probably take care of that, or they'll look into that. Now, what did happen is in that working relationship, there was good collaboration, good discussion that occurred with the Department of Justice, and appreciated their attitude. But it was nice to understand that we were never dependent. We were always doing it in such a way that if we had to, go it alone, we would be well prepared to do that. And so I think that also created within the team a concept that we had to be very professional and thorough in what we did and not allow any slack, because there wasn't any room for slack.
So there's a lot I could say about this, and let me start with the federal relationship, where there's a concept called cooperative federalism, which means that states have authority that is given to them by Congress to enforce federal law. This is an important concept that a lot of times people overlook, that the feds are not the sole deciders. And this issue came up last year, and I talked about it in a speech. I'll put it in the chat for everybody, where the head of the Antitrust Division said, if the Antitrust Division decides one thing, the states are not free to do something else. That was both an incorrect statement of the law and, to my mind, unwise policy, because the way cooperative federalism regimes work, like antitrust law, is the states act as a check, or the states act as a backstop. I'll give you a quick example in Colorado. The FTC refused to address a merger in Colorado Springs between one entity, it was United Health, and a provider group, DaVita, that we thought was going to have an anti-competitive effect on consumers, was going to raise prices for Medicare Advantage consumers in Colorado Springs. We took action independently of the FTC. And that's because that's what the antitrust laws do. They give the states the authority and the obligation to protect our consumers, even if the feds are failing to do so. And in this Google matter, in the Facebook matter, it was clear, as Doug said from the beginning, that we were going to be able to control our destiny and represent our consumers, regardless of what the federal government might do. And that meant how we pursued the theory and what type of complaint really was a testament to the state's leadership, and that was important to me. The other thing I want to note here, and again, it is a incredible testament to Doug's relationship skills, and I think the point that you made about John Saddle is important, and all of us can think about this in this year ahead, is how we lead with empathy. So starting with how are you? People may underestimate the importance of that. Doug's ability to build relationships at the AG level across the United States was critical in how the states are able to work together. And just to put a fine point on it, you asked the question, how do states work together? It takes a lot of work, because the Antitrust Division has a single head, and we have 38 states, and we have to coordinate among 38 states. And the way we do that is through relationships built on goodwill, on listening, on empathy, because different states may have different concerns, different circumstances, and the amount of time, particularly Doug, has put into listening, understanding where states are coming from. Sometimes you hear the metaphor herding cats. It's inherently a more challenging enterprise. I think it's a meaningful one because states are closer to the people. And so when we have a state attorney general, Herbert Slattery from Tennessee is a good example, who's really concerned about this issue and has specific rooted concerns, I think that it enriches the product that we're doing. And so yes, the relationships can be time consuming because you've got a lot of people you need to be engaged with. I also believe it can produce a better result. And plus we get the benefit of a large team that draws from all these offices that can bring together all sorts of different expertise. So I'm really proud of the team. I'm proud of the process. And I do think it bespeaks really well, particularly for Doug's relationships. And one final point, particularly for younger lawyers, and I think your point about John Dan gets to this, it's important to build relationships when you don't need them. Doug, I don't think you served in the legislature, but this is a comment I hear from legislators. You're going to need people down the road, so you need to treat them well all the time. And there are times when lawyers at our worst can be overly adversarial and not necessarily as, it's called emotionally intelligent, as maybe we should be. when lawyers build relationships, that makes a big difference because you're going to need those relationships.
AG Weiser, I remember you once sort of gave a more of a networking advice tip, but also a really good one is, when you think of someone, just reach out to them and let them know that you're thinking of them at that moment. That way, when you might need something in the future, it's you haven't reached out in a while. So I keep that in mind and trying to do better. So let's talk a little bit about Google specifically. AG Weiser, maybe you want to take this question, but what do the states claim that Google did wrong that violated the antitrust laws?
So I'm going to start quickly with the Microsoft precedent because, as Diana Moss said, there's not a lot of Section 2 Sherman Act monopolization cases out there. And what the Microsoft precedent made very clear is that if you're a incumbent monopolist and you control a platform and you see a threat to your platform and you engage in strategies to extinguish the threat, as Bill Gates famously said, cut off Netscape's, who is the threat, their air supply, that violates the antitrust laws because consumers get better products and services when there's competition, when there's choice. What we need to make sure we do with any platform monopolist is keep them on their toes and ensure that what's happening is competition on the merits. We investigated Google's control of two reinforcing monopolies, the search and the search advertising monopolies. And the questions that we were asking is, has Google taken predatory actions that are designed to exclude rivals, not on the merits, not competing with a better product, but by cutting off their air supply? And like Microsoft, our conclusions were there are several such strategies. One, and this is detailed in the federal government's complaint too, a range of exclusive distribution channels. So most famously, Apple is getting paid billions and billions of dollars to only carry Google search products. That, of course, disadvantages rivals. What we go on to address that the DOJ complaint is much less focused on is not just what has already happened. Think about the transition to mobile where the iPhone has the default being a Google search product, but think about next generation cars, for example, connected cars or other Internet of Things devices. Google's doing the same thing. Google is locking up the distribution channels, excluding rivals who then can't compete on the merits. That form of behavior, we believe, is predatory. It isn't based on providing better products, but is based upon squelching rivals. Another concern we had is Google has this valuable real estate of search advertising. They discriminate on who gets access to it, undermining these, we call them vertical specialized providers like Yelp or Home Advisor, because they see those as a basis for would-be rivals to get leverage against them. So they want to keep those providers essentially diminished so that they aren't a competitive threat. And they have created unique rules that disadvantage them relative to others. And finally, Google has taken control of these advertising platforms, one they call SA360 that helps place ads. And they promise to be neutral and to give advertisers a chance to advertise on Bing, which is the one notable rival, although super, super smaller. They haven't done that. They've degraded Bing's access to this advertising platform. So from these sets of strategies, Google has identified potential competitive threats, has taken action to limit them, and is hurting consumers.
We mentioned earlier talking about the role of the federal agencies and that the U.S. Department of Justice had filed an earlier complaint against Google a few months before the states. I'm curious, why did the states, I should clarify, is there were 11 states at that time who joined the Department of Justice, but why did the other states wait and file another complaint and not join US DOJ at that time?
Yeah, I can go ahead and respond to that. As I said, we started approximately 3 months after DOJ had started their investigation. And so it was obvious General Barr had made some comments publicly that he wanted to move quickly on the Google matter and wanted to get something filed fairly quickly. And we felt we couldn't compromise our independence and ability to fully investigate. And at the time, there were still some outstanding investigative requests that we had, and we just felt once again, this independence was important, collaborating, but maintaining our independence. And so our message to the Department of Justice, who've been very good to work with, was we're not going to be able to join you on the day of your filing because we have to complete this discovery. We have collaborated long enough to understand that we're very confident that you're going to put together a good complaint. And we will be following on the heels of your complaint in a matter of a couple of months. And that's what in effect happened, because I believe they filed in October 16th or something like that. And we were mid-December. So it was just, as I said, it was a very good working relationship, but we also wanted to expand a little bit on some of the factual concerns that we had, some of the innovative technologies that were being affected, and also elaborate a little bit more on our vertical search concerns. So, and going forward, now that the complaints have been filed, we've again continued to have good communication, and cases have been consolidated for discovery. So it will be an important federal-state partnership as we go about trying to show that Google, as Phil has explained, improperly affected competition in these markets.
So today we are talking about data and privacy. And General Peterson, I'm curious how the data piece plays in the Google case.
You know, it's really important, because I think what everyone has come to understand is data has a tremendous amount of value. And Google, over its 22 years of existence, has developed through search a tremendous amount of ability to acquire. And when you consider the number of products that Google's put together, from Gmail to Maps to so many of their products, they're tremendous individual fact gathering, data consuming products. And it's always based upon convenience. So the average consumer will look at the agreement, but need the service, want the maps, want whatever, go to Gmail. And in effect, they've become one of the most dominant. They and Facebook, from a social media standpoint, are gathering a tremendous amount of information. Well, that we all understand that information has value. And so that gets into a variety of different issues, from consumer protection, privacy issues, but it also goes into market dominance, because if you control so much information and continue to block off innovative ideas of other companies because it's a threat to being able to accumulate the information, it becomes the gold or the oil product of technology. They want that data, they need that data, because they can go to the markets and dominate by saying, we have so much more data on consumers that we can sell to you to target what you want to do in marketing to those consumers, that no one can touch it. And so that's dangerous in a lot of different ways. And it's what has allowed them to be the dominant position that they have, is because most who want to sell in the retail world will know that Google, in a lot of ways, is the only game in town. What's interesting is when some of these vertical search companies came and they said, you know, Google developed just a fascinating product back in the late 90s with the ability to scrape and index and really created an impressive search product. Then you have some of these other companies that say, well, look, we're going to do a completely different model. We're not going to be so tech driven, but we're going to do more of individualized markets and consumer reports and information. Those should be able to compete in the market with a different, more focused and individualized analysis of a product, so that consumers can say, well, I'm interested in knowing what people think about this hotel or these restaurants. That should be a consumer product that they should be able to freely go to and not be pressed down because of Google's control of basically the digital shelf. And so these are things that are important, because it ultimately does come back to the consumer and their ability to make their own choices. And also it gets to the broader question of their ability to maintain privacy on their data.
So Diane, it's Consumer Privacy Day today. And as we think about data privacy, there are a few points I'd underscore, both from what Doug said and then going back to the earlier panel with Danny and Diana, who I thought did a fabulous job. First is consumers who don't have choice are forced to take less privacy protective policies. And in theory, if you had a free market where a DuckDuckGo, who promises more privacy protection, had a fair chance to compete at the merits, didn't face the sort of predatory tactics that we're concerned about, consumers could vote with their feet. But right now, that's not the situation that consumers find themselves in, and they don't get that benefit of choice. Second, and this just quickly jump to the Facebook case, we won't have as much time to talk about it. In that complaint, you'll see we talk about when Facebook faced more threats of rivalry, they were more protective of privacy than when their monopoly was more entrenched. And that's an important point that I want to close to. And I think this is what Diana Moss said, whether or not a product protects privacy or not is a quality dimension. And part of the challenge is people say, well, Google's product is free. What's the problem? Well, if it's a lower quality product because they don't face competition and consumers don't have any place to go to get the privacy protection they may want, that's bad for consumers. And this is a consumer issue. Will consumers get choice in the marketplace, or will that choice be snuffed out through predatory tactics? And that's what both these cases are about.
Well, I do want to allow some time for Q&A, and I see we have a number of questions. So if unless there's anything else we want to say, should we move on to the questions?
Let me just say one quick thing about the Facebook case, so we add that one flavor. The Facebook case is also about predatory tactics. The specific strategy was either we're going to buy you as a rival or bury you. And so to put a small point on it, Instagram, WhatsApp, real rivals, could be game changers. They get bought out and taken out as competition. Others like Vine, which was a social networking platform that Twitter tried to develop, they got snuffed out through predatory tactics. And that was the story there, which is also a story of undermining consumer choice and harming the innovation in an ecosystem that previously had competition. And this is an important point. I think Doug made it, I'll underscore it. Facebook and Google obtained their monopolies by developing a new and better product. Google's product was better than Alta Vista. That's consumers voted with their feet. Facebook's product was better than MySpace. Consumers voted with their feet. But once they got that monopoly, they then used anti-competitive or predatory means to maintain that monopoly, and the antitrust laws don't allow that.
Yeah, and it's really killed innovation, because think of how many upstart companies are just overwhelmed by the fact that they can't enter into this market because of the data monopoly control. And investors are going to look at this and say, well, seriously, you want to go compete against Google? I think I'll keep my money because you'll get squelched.
And it's worth underscoring, we had an antitrust hearing in Boulder. Jonah Goose is on the antitrust subcommittee, hosted us. We had companies who said, this is the world we're now living in. And I've had investors say to me exactly what Doug just said, which is there's sort of a kill zone. If you're anywhere in the zone of threatening a Facebook or a Google, investors see it and think, I don't think so.
Right, thank you. So moving a little bit on to, we've talked about what the states have alleged these companies did wrong, but talking about remedies. And so one of the questions is, can the issue of big tech antitrust be solved solely through litigation, or does it also require new legislation that addresses 21st century business models?
Doug, I'll give my first shot on this, and there are a few answers I'll give. One is, we're going to give it our best shot. In both these cases, we're asking for both structural relief, which includes ideas like divesting elements. So obviously in the Facebook case, it would be divesting Instagram, WhatsApp. Also conduct remedies, which have to be managed effectively to address things like discrimination that hurts competition or ending these contracts that are anti-competitive. So that's a case we're going to make. Second, there's discussion about, are the antitrust laws being interpreted in a way that really has taken the teeth out of Section 2? That's an important conversation that's going to be happening in Washington. And then there's other conversations. Do we need some sort of internet platform regulatory agency, because these platforms are so important on competition, maybe on privacy or even on speech issues. Those are conversations as well. What I will say for sure is if we can't effectively protect competition through the antitrust laws, those other sets of questions are going to get a lot more momentum behind them. I believe we are set up to be successful here, and it's important that we do our jobs to do so.
Yeah, Diane, what I would say to that is I see three methods of trying to bring competition back into these markets. One is our litigation process, but everyone knows that there's no certainty and it takes a lot of time. But the Microsoft case that Phil mentioned earlier, did a lot to open up markets. And so that is a good model for us to work through. The second thing is with regards to legislation, one of the concerns I hear is that these companies are such dominant players that their ability to work something out favorably ultimately through what takes place in DC is concerning because they do have a strong presence and some don't have confidence that any meaningful change will come out of that. The third one, and it's kind of an irony, but the third is the market itself and consumers. What can consumers do to influence the market? I think it's a very powerful one, potential influence in the market. But the concern is that this dominance has become so big, the dependence so big. Can people use their feet, their choice in a large consumer movement to change things? I think that's starting to happen with privacy a little bit. But I would say within the market, these companies who understand that right now public sentiment is building up against them, they certainly know how to market. And what I would say is talk is cheap, deeds are precious. So I really want to see the consumer effort always be there because ultimately I would like to rely on the consumer's ability to impact the market through their choices as opposed to depending upon the government. But I don't know if the dominance by these companies makes that very, very difficult.
I will say related to Doug's point about that third category, these companies like Microsoft are also held to account in the court of public opinion, and that's related to the market idea. And the public views about Facebook and Google, I believe now reflect the concerns that are addressed in our complaint. And we will be using the levers we can to restore competition to this market.
And General Peterson, you actually answered one of the questions was, is there anything consumers can do to help AGs in this fight? And what are some things consumers can do to better protect themselves? So I don't know if there's anything else you want to add on that. But
well, there's a commercial announcement here that we have to give. StopFraudColorado.gov is the Colorado site where consumers can share their feedback with us. These cases reflect a lot of feedback that I've gotten from consumers and from innovators, from companies who are concerned about it. Your voice matters to us. I often say our democracy is a team sport and we need people engaged. So please keep sharing your frustrations. I know Patrick talked about robocall, something that Doug and I are also working on, both within our states and nationally. We need your engagement, getting the word out, sharing the word with us as to what you're seeing and what your pain points are.
You know, the other thing I'd add to that, Diane, is I do think it's very important for consumers to kind of step back and look what is going on in the media markets, in social media. I think the social dilemma came out, and a lot of people found that to be very interesting to see the tactics that are used to keep us glued to these phones. There's a great video out called Childhood 2.0, and it talks about the impact on our high school students, the greater degree of depression, dependency, anxiety, because they're just constantly looking for approval through the phone system. And I wouldn't limit it just to some of these monopoly concerns, but to a much broader concern of can we step away, and is our quality of life better if we can step away from our dependency on these devices and the social network. And that's the movement I would like to see, because then they can have less of my data. And as you look at data, artificial intelligence, there's two polar effects going here. They want as much data as possible. They need it to feed to the artificial intelligence analog. I think I don't want to get too far down that road, but with artificial intelligence, there's certainly a greater demand for data so that our life can be more convenient. And I just think consumers need to become more aware is what do they sacrifice for that convenience? And how easily will they allow that data to be taken, and how deep will it go into our health issues, into so many different things that are concerning. So I would love to see a movement where people learn to get away from the internet and get more relational with people and get, some say, you're living in a fantasy world to think that that could happen. But I really would think it's even broader than just getting away from Google search and Google emails, but frankly, getting away from the internet.
Well, Doug, I'm with you in that ideal of community, because one of the risks of social media that we have suffered is the algorithms used are driving polarization and are driving demonization. And if we can be citizens, fellow citizens, that is the United States of America at our best. And I do think part of the conversation that's happening right now is a awareness, just like you said, the Social Dilemma movie, pulls some of these themes through. Are we being spun up? Are we being set up? Are we being manipulated? People need to be asking these questions critically, and people need to be citizens first, human beings first, and not victims or plugged into their phones by likes or by an outrage machine. And that is something that, again, as you talk about kids growing up in this world, we have to be aware of these dynamics.
Yeah, we're tools. We're being treated as tools. Our children are being treated as tools. And I think when we step back and look at that, that's kind of offensive. And so we need to have a better understanding of how do we actually engage with the internet.
So on that note, we do have to wrap up, unfortunately, and we had a lot of great questions, but thank you both, General Peterson and AG Weiser, for your time today and for this great discussion, and we'll continue the dialogue.
I've got to go. Salad's on the phone.
Thanks, Diane. Great job. Really enjoyed it. Thanks, everybody, for joining us.
All right. Bye-bye.